Hello again, this is Ben Hitchcock Cross talking to you today. I said I'd be right back, but you know how these things go. 2 hours later, something like that, and we've got a case here. I'm just going to hit right into it. I think it's fantastic on the subject of what we got going on here. So we'll just read it out loud on bias, on bureaucratic bias, on internal that's what I'd say, on bureaucratic bias, on the agency has a long memory. I think that's the big quote here. All right. And this is an agency that had a long memory back in 1988. So we'll get that 90. 90, when's this decision come out? Yeah, 90 something. We can. Ooh, baby. Yeah, we'll leave it. All right. You can see I'm going to paraphrase some things here, but we'll also learn together. The main thing that I want to focus on is these statements by the hearing examiner back there, okay? Yeah, there's some big mistakes in there, but we'll leave it alone. An administrative law judge, Robbie L. Phillips versus Milwaukee County Medical Complex. An administrative law judge for the Equal Rights Division of the Department of Industry, Labor, and Human Relations issued a decision in the above-captioned matter on February 14th, 1989. Complainant filed a timely petition for review of the administrative law judge's decision, and respondent filed a complaint to the complainant's appeal. Now, if we were to go and look at our handy, maybe it's upstairs for personal reference, Roseanne Wasserman's Guide to Employment Law in Wisconsin, we would know that in 1988 they changed the nomenclature from hearing examiners to administrative law judges. I wonder what happened in 1988 that caused them to feel so that they needed a boost in stature, to administrative assistant or something like that. All right, here's the key thing, because this is, when I see this, I'm always going to raise a red flag. The respondent, Milwaukee County Medical Complex, is a medical facility operated by Milwaukee County in Milwaukee, Wisconsin. Now, again, I would say, generally speaking, the allegation here, so basically, is the MPS ERD is really not fit for dealing with the largest employers in the state of Wisconsin, but that are large governmental entities, coinky-dinky, particularly Department of Corrections, Milwaukee Public Schools, Milwaukee County. That's, I think, what we're trying, one of the things that we've highlighted here. So this is Milwaukee County in another form, the Milwaukee County Medical Complex. Yeah. This is just for reference and the thing. I don't think we'd put this in that formulation these days. Complainant Phillips is a black person, was first employed by Milwaukee County in 1981 as a clerk typist 2. She worked as a clerk typist 2 in a variety of county offices, including yada, yada, yada. Okay? She worked at the medical complex. Findings of fact, findings of fact, findings of fact. Dunham did not use racial slurs towards Phillips or make any overtly racial remark towards her. When Phillips complained to Dunham that her co-workers were directing racial slurs toward her, Dunham talked to Phillips' co-workers and told them that such conduct would not be acceptable if it was. Boy, does that sound familiar. Yeah, a lot. Times have not changed, huh? Okay, no one in Phillips' workplace used racial slurs towards Phillips or made overtly racial remarks to her about her in her presence. She made it up. Shucks darn it, okay? Dismissed. Okay. Memorandum opinion. Now, bias. It's a little bit weird that there's a bias decision here, but it's all getting dismissed anyway, but okay. It's also, these old ones, they will not say the name of who the ALJ is, but I guess if it's 90, we won't have that issue around. Bias of administrative law judge. Phillips points to two respects in which the hearing examiner allegedly showed bias. First, she asserts that he criticized her representatives in connection with an amended complaint offered on her behalf, making comments concerning an unrelated case. Second, she asserts that he asked her if she had a gun when she first came into the hearing room, stating that he was concerned about the safety of witnesses. Oh, let's see how they deal with that. Based on, I mean, imagine that, to be a black person to go to the state office building and to be asked by the so-called administrative law judge straight out, how is that person... How is that person employed as an administrative law judge thereafter? We have to get the name of that. We're going to have to do that because, my assumption is that person retired safely from the state of Wisconsin with a pension and all the rest, but they should have been terminated from their employment in 1980. Who asks if they have a gun for the safety of the other witnesses? All right, but let's find out more. Based on the review of the record and the hearing tapes, the commission finds that these allegations are essentially correct. Okay, I'm going to have to write an email. You'll excuse me for a second. All right, well, once again, there better be something in here that says that there's some evidence to think that Robbie Phillips, a female black person, is carrying a gun at this hearing in the state office building in 1988, or it's my contention that this person should have been fired. What the hell is going on? I literally do not care that it's 30 years old. It's absolutely unacceptable. I bet you that person continued to keep going there and continue to train others. And you would assume that much of the behavior that we see exhibited today makes sense if this kind of behavior is tolerated. On October 7, 1988, an amended charge of discrimination was filed. Can we do it? Can we do it? I think we can. Let's try it. We can't. Was filed on Phillips' behalf, alleging handicap discrimination and illegal retaliation. Phillips was represented by attorney Joseph Radke. Also present assisting Radke was Miles Notaro. I'm just guessing, just by the last name, that he's not necessarily a white person. A non-lawyer assistant employed by Radke. After a few innocuous preliminary procedural matters were addressed, can we please? I am nervous about doing it. All right, sorry, Ben. The administrative law judge made the following comments. Mr. Notaro has a reputation around our office for three things. Yeah, and so another little bit goes by. Why? Because Notaro sued Radke for terminating him. And that went all the way to Lurk. And Lurk kind of put some shade against him, which is really fascinating to me. They say in here that the question of Notaro's subjective beliefs about his claims of discrimination are important here because of all the underlying allegations in which Notaro's opposition to involved were rejected by the investigator, and Notaro did not appeal these no probable cause determinations. I'm sorry, let's see. The ALJ expressly found that Notaro did not have a reasonable good faith belief that he was being discriminated against when he engaged in his opposition. Rather, the ALJ concluded that Notaro made his allegations of discrimination without believing in them, merely in order to put pressure on respondent to settle a purely contractual dispute and to set up a potential retaliation complaint later if any adverse action was taken against him. Based on the review of the record, the Commission fully agrees with the ALJ's assessment of Notaro's subjective beliefs. It arrives at this assessment not only because of its acceptance of the ALJ's reading of Notaro's credibility as a witness, but also based on its review of the record. Among factors considered by the Commission were the fact that Notaro testified inconsistently on a point that was material to the question of whether he had ever really believed he was being discriminated against. But what is important here is that Notaro had earlier been willing to swear under oath that someone admitted something when in fact it was only something he assumed. This shows a penchant for exaggerating and embroidering the truth, as well as a disregard for the significance of the testimonial oath, which in turn justifies doubt as to his other testimony, such as his claims that he genuinely believed that he was being discriminated against. Wow. That's going to be fascinating in conjunction with what we read later on. Fascinating. Fascinating. Did not expect to find that. Fascinating. Hold on here. Holy cow. So we're back in Phillips. All right. And Miles Notaro shows up, a non-lawyer assistant employed by Radke. Okay. Mr. Notaro has a reputation around our office for three things. One is for doing what many ALJs view as practicing law without a license. That's problematic to me, parentheses here. That's problematic to me, Ben Hitchcock Cross, because I don't believe that you actually need to be an attorney to represent anybody in administrative law. So that is a lawyer's bias against a non-lawyer statement. Problematic. Secondly, when he is doing so, to not do so competently. And third, to abuse our process. That means filing things he thinks for no reason, with bad intentions. It's more than that. Here's the kicker. This agency has a memory. We will give anybody who appears before us the view that anything that is done is legitimate until it is shown otherwise. Part of the situation today is that Mr. Notaro and the firm that he used to work for had a particular reputation here of abusing our process. And we do not stand for abuse of this process. This document that I have before me, I have the sense of what is going on in cases. I practice privately and have some sense of what is going on. This smelled like a delaying tactic. I'll be clear on it, and I do not take such things lightly. It is in our view, as far as this is dealt with, it is my policy to treat all legitimate claims with great respect, to give them time. I will, however, not allow abuses of any other party's time for something that should have been done far before. If you are not ready to proceed in dealing with this amendment, then I will simply rule on the fact that on that ground. Okay? Now, I'm going to put in a fact here that I know just of last week. Thank you, ALJ Reinhardt. All of the ALJs meet together once a week and discuss cases. I'm going to say that again. All the ALJs meet once a week to discuss their cases. So that might be important to keep in mind with what this ALJ just said there. The ALJ was evidently referring to an amended complaint which had been filed on Phillips' behalf. Attorney Radke explained how he had been retained to represent Ms. Phillips after her former attorney, Alan Eisenberg, was disbarred. Alan Eisenberg was disbarred several times. This is like, I'm like 4 years old here, 10 years old here, fourth grade, rocking it. Possibly early Simpsons time is what we're getting into. I'm saying here that much later in my life career, if I saw Alan Eisenberg driving his big white Cadillac down the street, I would pull over to get out of his way. If I saw him coming into the room, I would pull over because there was a confrontation waiting to happen, and I didn't want to be involved in it. That's my feeling. And how Mr. Notaro, who had formerly been employed by, says Mr. Notaro, but I assume it's Alan Eisenberg, was hired by Mr. Radke's firm to assist in representing a number of clients who had been transferred from Mr. Eisenberg's firm. Radke also denied that the amended complaint constituted an abusive process or an effort to delay the proceedings, noting that the complainant had in fact opposed a request for adjournment proposed by the other, and in fact, far from hoping that the amended complaint would delay the proceedings, his firm anticipated that the amended complaint would be handled as a separate matter from the then pending complaint, thus not delaying the matter. The administrative law judge made a number of comments criticizing the amended complaints for certain errors in spelling, pesky employees of names, and for the absence of certain dates, called it improperly drafted and sloppy. I'll keep that in mind for future reference, is what somebody might have said to that ALJ at that time. And criticizing Attorney Radke for allegedly not reviewing it after it was apparently drafted by Mr. Notaro. After some further discussion concerning the timeliness of various aspects of the amended complaint, Attorney Radke requested to be allowed to make response to the comments of the administrative law judge concerning Mr. Notaro, and that the administrative law judge was, opportunity notice to be heard. I mean, seriously? This is like deja vu all over again, Ben says in a parenthetical comment. He can deal with that by changing his practices in the future. My statements today regarding what was going on today, even though I will still view the facts of this case in the fashion, regardless of Mr. Notaro's or anything I said about his former office and its importance. I believe to understand that this process requires a lot of good faith on a lot of different people's parts, and when situations occur that result in a behavior that I, as an ALJ, viewed as detrimental to the process, it's important to remember that there are consequences to that stuff. That sounds like we'll deal with this matter of this hearing being recorded at a later date kind of thing. His statement today, I'm not going to waste the other parties. If you wish to submit any documents to me, I've already made my decision, is what I hear there. To me, regarding an explanation, I will look at them, but I am not going to waste the other people's parties here dealing with Mr. Notaro when the issue here today is whether or not Phillips was discriminated against. Man, I've heard that too. Deja vu all over again. After the ALJ stated the issues of the complaint and summarized his ruling on the amended complaint, Attorney Radke made an oral motion that the judge disqualify himself for bias. The administrative law judge responded immediately, not allowing any argument by Radke in support of the motion by stating, I will not. Oh, I love that. I will not because it doesn't. I'm not going to. I feel completely capable of judging the merits of the case and capable of separating the situation of what happened regarding Phillips and the issue of reputation based on prior contacts with certain people and the way certain other things have been conducted. So I will not do so. And I don't believe that it's warranted. Shabam. What the heck? All right, this is even more bizarre. After the first day of hearing, but before the second day of hearing, the administrative law judge wrote a letter, and I assume this is a straight-up letter, not getting to him for 2 days. On November 3rd, I made some comments during my treatment of your amended complaint as a motion for leave to amend. I believe it is a misinterpretation of my comments to conclude either that I can speak for other administrative law judges. I bet you he got him. That the division has any policy regarding your firm. Boy, I know what Mr. Radke feels like, one can imagine. Or that you would get anything other than an impartial hearing from any of the other ALJs. I have no intention of suggesting any of these things. I believe that each administrative law judge in this division will give any client you represent a fair hearing. Moreover, I am convinced that I am giving and will give an impartial hearing to your client. Man, that's just who you want to be convinced. That's exactly the person. Man, if there was another one that was better than Deja Vu all over again, I would be saying it here for variety. But since there's not, I'm not. I love researching. I love research rabbit holes. All right, guys. I decided when I made my ruling that I would stay on the case, and I still come to the same conclusion after considerable... We literally heard that from Leanne Fraley. Wow, school board member Wauwatosa, and I'm pretty sure Stephanie Brown as well. That might be paraphrasing, but it's almost verbatim for Fraley, but okay. I still come to the same conclusion after considerable reflection. I have no stake in the outcome of the case. I had and still have no preconceived idea of whether or not your client has been discriminated against. I will not bring up the issues I addressed or considered them in my rulings. Oh, well, that's nice. That's great. Where have we heard that? Thank you very much, Gelhard. The more things change, the more they stay the same. Wow. All right. The other of, let's just read this because I bet you it's going to be fun. The other allegation of bias against the administrative law judge, and remember 1988, 1990's old history. Nobody was alive then who's in power today. That's not possible. All right. As she entered the room at the beginning of the hearing, whether she had a gun, stating that he was concerned about the safety of witnesses. Now, while no such incident is reflected on the hearing tapes, the commission nevertheless concluded that it occurred, as Phillips alleges, most probably prior to the time the administrative law judge turned on his tape recorder and opened the record. This conclusion is based on the presence in the division's files of a memorandum from the Director of Legal Services Bureau to the administrative law judge dated November 1st, 1988, in which the director indicates that a subpoena witness, Chris Pacaganella, had telephoned to ask if Phillips would be checked for weapons prior to the hearing. On November 3rd, 1988, indicating she was fearful about what could happen to her since she considered the complainant to be unstable. Now, one assumes that at the immediate opening of the record that the judge would notify the parties of that ex parte communication. Doesn't look like it happened. We'll see. Director's memo reflects that he advised the caller that it was not the normal practice of the division to frisk complainants before the hearings commence, and that he asked her what led her to conclude that it would be advisable to check the complainant for weapons, and that she indicated that the complainant was on a lot of medication and had made a lot of threats. According to the memo, the director advised the caller that the matter would be for the administrative law judge to decide. A handwritten note on the memorandum reflects that the judge made 4 attempts to telephone. He's doing independent research now? Wow. But that they were unsuccessful. The commission infers from this that the ALJ probably did inquire of Phillips whether she had a gun when she arrived at the hearing on the following day, as Phillips asserts. Well, that's nice. How about just Phillips say so? What more could they possibly need than that? I mean, she's a black woman, and it's 2024. I mean, 1988. Hey, here's something we just read. An administrative law judge should recuse himself if she determines that she cannot be impartial in a matter. She should also recuse herself even in cases in which she subjectively believes that she can judge a matter impartially, where her impartiality could reasonably be questioned by others because of an appearance of bias on her part. Thank you, Judge Reinhardt, for showing us that. All right. Hey, State versus Asfor, State versus Wahlberg. Well, now we know where he got it from. Deja vu all over again. Okay. A mere showing of antagonizing or a strained relationship between counsel and the court. You mean the tribunal? Containing an attorney employed by the governor of the state of Wisconsin and two other people, possibly attorneys, employed by private people? Okay. Thus, in Kane, the disqualification of the administrative law judge was not found necessary in an equal rights case in which the relationship between the judge and the counsel for complainant deteriorated during a hearing in connection with numerous arguments over evidentiary points and the adequacy of the evidence. However, the commission considers that the significant appearance of judicial bias against counsel may be greater in cases in which apparent bias is not evidently connected to the case in which both are participating, but rather arises from something external to the case. That's probably sound reasoning. This was apparently the situation here. The comments of the administrative law judge quoted above make it apparent that he brought to the hearing a predisposition to view negatively the representatives of Miss Phillips. Period, the end. This predisposition did not arise merely from his views as to the adequacy or intentions behind the amended complaint which had been filed on Phillips' behalf. There were obvious other sources for this predisposition. Thus, the administrative law judge referred to Mr. Notaro having a, quote, reputation around our office for doing what many ALJs view as practicing law without a license, not doing so completely and abusing process. He referred to the memory of the agency, the reputation of Notaro before the agency, and the issue of reputation based on prior contacts with certain people. That these comments could create the appearance that the administrative law judge was biased against Phillips' representatives in connection with matters external to the case at hand is borne out by the fact that this is precisely what Phillips, a layperson, comments to her representative regarding the previous case. How was it possible then for Mr. Notaro to have ERD hearing? Given that I don't understand. Make that make sense if you would. This is astonishing, and so we're going to read it out loud together. Furthermore, the ALJ's conduct in confronting Phillips when she entered the hearing room and asking her if she had a gun is disturbing. Should have been fired right there. Entirely apart from the question of whether his conduct may be seen as evincing actual bias on the examiner's part towards Phillips, it certainly created the appearance of such bias. There better be some mention in this paragraph of racial bias. There better be. The informant, on the basis of whose unverified suspicion the judge apparently acted, was a former coworker who Phillips accused of racially harassing her. How was that judge allowed to continue to be an ALJ? Because of his conduct there, and because the statements, his conduct makes it clear that he's treating black females differently, and that he's predisposed to believe the statements, just like Lurk was predisposed to not believe the statements of Miss Phillips. The judge is also predisposed to not believe the statements of Miss Phillips. It just smells of racial bias to me. Remember, these organizations are created to identify and cure racial bias in the workplace here. Wow. Confronting Phillips upon her entrance into the hearing room and asking her if she was carrying a gun not only created the appearance that the administrative law judge had arrived at a prejudgment concerning Miss Phillips' character and is racially biased and should be thrown out of the job and not ever given a pension. What the hell? Sorry, it says Ben Hitchcock Cross. Excuse me there. But also could be seen as indicating predisposition to credit. Oh, yeah. Also, he's not supposed to do investigations on his own. What does he do connecting witnesses? Why is all this happening ex parte? They only find out after the fact. Oh, come on. You ready? You ready? You ready? Let's do it. The commission concludes that the concurrence of these two events, the inquiry, the two events, you need both of those things? The inquiry as to Phillips and to whether she had the gun and the comments during the hearing concerning her representatives created the appearance of partiality on the part of the administrative law judge serious enough that the disqualification was warranted. The issue thus presented is whether, as a consequence of the administrative law judge's failure to remove himself, Phillips was denied a fair hearing or impartial decision. Based on its careful review of the record, the commission has considered that it was not, and the administrative law judge's error in failing to remove himself from the case was harmless. Luckily, there's Supreme Court opinion now, pretty sure there was back then, that made it clear that you can't, substantive due process error is not harmless. And so now they're going to say there's stuff in the record that says we can independently back up the judge is what we're going to do. That's exactly what they're going to do. Who signed their name to this? Nobody signed their name to this decision, huh? We'll have to get it. That Kevin C. Potter, Carl Thompson, Pamela Anderson. That's flawed. Deeply flawed is what I would say. Just on the reasoning there, even slightly that even to the extent that they come to the correct conclusion, the racial bias in there is palpable, in my opinion. Wow. I would not sign my name to that document. I would feel that would implicate me in some things that I don't think are fair. And also make me feel like I was unqualified to do my job, but that's me. Okay. Wow, that was just shocking there. Again, I really want to point out to what lengths they had to go. They could have simply just believed Miss Phillips just from the get-go. And if given those two statements, the fact is it really shouldn't matter whatever happened after that. That judge should have lost his job, that a hearing examiner should have been booted. They should identify that hearing examiner so it never happened again. I don't understand how Mr. Notaro can possibly have a fair hearing given these statements there, or doesn't raise this issue, and nobody seems to bring it up. Yeah, I'm shocked. But hey, we live and learn. All right. You think we should stay out of here? Oh my God, it's getting late. Live and learn, guys. Live and learn. Stick with us. We'll keep you informed.